Prince Harry wins right to appeal rejection of publicly funded security detail in UK. Prince Harry has been given permission to appeal the British government's rejection to provide him with publicly funded police protection in the UK. The Court of Appeal gave the Duke of Sussex the go-ahead to challenge a ruling earlier this year in the High Court. The permission was granted in May but only reported Thursday. Judge Peter Lane ruled in February that a government panel's decision to provide bespoke security on an as-needed basis after Harry quit as a working member of the royal family was not unlawful, irrational or unjustified. Welcome to Royal Pancakes. If you are new here, please don't forget to subscribe and click the notifications bell, so you don't miss any news about the British monarchy. Insofar as the case-by-case approach may otherwise have caused difficulties, they have not been shown to be such as to overcome the high hurdle so as to render the decision-making irrational, Lane wrote. The long-running fight began more than 4 years ago when Harry first challenged the panel's decision, arguing that he and his family need an armed security detail because of hostility directed toward him and his wife Meghan, Duchess of Sussex, on social media, and relentless hounding by the news media. Harry, 39, the younger son of King Charles III, has bucked royal family convention to challenge the government in court and sue the tabloid press. He won a big victory in December after a judge found phone hacking at Mirror Group newspapers was widespread and habitual. He has 2 similar cases remaining against the publishers of The Sun and Daily Mail. The security case appeared to be dead after the High Court in April rejected his first request to appeal Lane's decision. But Justice David Bin on the Court of Appeal said on May 23 that he could challenge the lower court decision. Prince Harry's request to expedite his appeal against a High Court ruling on security was denied by a Court of Appeal judge who said he could not jump the queue. Prince Harry was this week granted permission to appeal against a decision made in February that backed the government's right to deny him automatic police protection. He wanted the appeal to be heard by the end of July, in part due to fears that the ruling would influence the approach other countries take to his security. With the Sussexes understood to be planning multiple overseas tours in the coming months, the Duke argued that the litigation had already dragged on for 2.5 years and said his legal team would be busy with other matters from October. However, while Lord Justice Bin allowed the appeal, he refused the application to expedite proceedings. The judge noted, "It is rightly not suggested that the claimant is entitled to jump the queue because of his status." He dismissed the Duke's argument on timings, pointing out that he had not lodged legal proceedings until 18 months after the decision was made to withdraw his right to automatic security in February 2020. Prince Harry did not seek a judicial review until September 2021. In February, he comprehensively lost the case in a scathing ruling handed down by Mr. Justice Lane, who insisted that the decision made by the Royal and VIP Executive Committee, REVEC, had not been irrational or procedurally unfair. The Duke lodged a request to appeal on 5 grounds, most of which were rejected, including a hopeless argument on costs. However, Lord Justice Bin said that ground 1, which is understood to suggest that REVEC failed to follow its own written policy, would have a real prospect of success. He also concluded Mr. Justice Lane may have erred in concluding the Duke was not in a comparable position to those in the other VIP category, who receive state security. The Prince's other arguments were branded unpersuasive. Lord Justice Bin said Mr. Justice Lane was plainly entitled to find that the Duke had the ability to make representations as to how he should be treated. He also found that the potential impact of a successful attack on the Duke was at the core of REVEC's deliberations and that as such, there was no prospect of the judge's findings being disturbed on appeal.